Hello, and welcome to Lesson 2, an analysis of case law supporting the Negro hunting license. In this lesson, we will explore the legal framework that has allowed the use of deadly force by the police, as well as the impact that this has had on communities of color, particularly African Americans. Our first case is Graham v. Connor, a Supreme Court decision that established the objective reasonableness standard for the use of force by police officers. Basically, this case held that an officer's safety comes first, and infringing on people's rights comes second. This decision, in effect, changed the view of police use of force from that of an individual encountering a state action that could potentially be a violation of the person's constitutional rights under the Fourth Amendment to that of the police officer's right to act and use force if they feel it is reasonable. A key sentence in the decision is the following: the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene, rather than with 20/20 hindsight. On its face, this decision seems race-neutral, meaning police have the power to kill anyone. But in practice, it has resulted in the following statistics. In 2019, police killed 1,099 people. Black people were 24% of those killed, despite being only 13% of the population. Black people are 3 times more likely to be killed by police, and 1.3 times more likely to be unarmed compared to white people. About 1 in 1,000 black men and boys in America can expect to die at the hands of police. 99% of killings by police from 2013 through 2019 have not resulted in officers being charged with a crime. Next, let's take a closer look at California Penal Code Section 196, which states that a police officer may use deadly force when arresting persons charged with a felony and who are fleeing from justice or resisting such arrest. This standard has been interpreted broadly, allowing officers to use deadly force even when there is no immediate threat to their own lives or the lives of others. In California, the basic reason why police officers are almost never prosecuted when they kill black people, even when the circumstances indicate that deadly force was not needed, is because of this penal code. California Penal Code Section 196 is the single oldest unamended law enforcement use of force statute in the country. In summary, the license to hunt and kill African Americans is a centuries-old apparent rite of passage among law enforcement in the United States that is still thriving and only seems to be gaining momentum. The legal framework around police use of force has a profound impact on the safety and well-being of communities of color, particularly African Americans. By examining case law and statistics on police killings, we can better understand the problem and work towards solutions that promote justice and equity for all. In our next lesson, we will examine those solutions.